Good morning. Morning, everybody. We're just going to wait a couple of minutes to give everybody a chance to join. Right. Good morning, everybody. I think we have a critical mass here. I want to welcome the attendees. My name is Robert Nichols. I'm with Nichols Liu LLP, law firm here in Washington, D.C. We're a government contracts law firm, and government contracts is all we do. Want to introduce this webinar. This is the second in a series of webinars that our firm is doing on the Stafford Act Public Assistance arbitrations, or as we and the board call them, FEMA arbitrations. The purpose of the first webinar a couple of months ago was to introduce this crowd to some of the judges from the Civilian Board of Contract Appeals and FEMA's Director of Arbitration. They could not necessarily get into details of cases, but I think gave you a good sense of who they are, how they approach things. The purpose of today's webinar is to get into more detail about the cases that we couldn't discuss last time. We've arranged the cases into 6 broad categories based on the frequency of the issues as they've come up before the board. I'd like first to start, though, by talking to our special guests, have them introduce themselves, and then I'll also introduce our other Nichols Liu folks, and we will go from there. Molly, do you want to start?
Sure. Good morning, everyone. My name is Molly Bargeman, and I am Director of Recovery for our federal portfolio with AC Disaster Consulting. We are a small women-owned firm nationwide across over 30 states. Personally, I have nearly 15 years of disaster recovery experience, spanning from Florida to state experience with the state of Nebraska for several years. And I'm currently assisting, I guess majority of my work would be Hurricane Ian recovery right now, but excited to dive into some of these. Thank you.
Terrific. And Molly, can you tell us a little bit about the services that your firm offers?
Yeah. So when AC Disaster Consulting started in 2018 after Hurricane Michael, really started as a recovery firm. Definitely FEMA Public Assistance, hazard mitigation, leveraging federal funds. Really, I think our foundation is in that recovery space. In the last 5.5 years, we've really expanded to full spectrum to include mitigation and resilience, planning and preparedness, as well as operational and response capabilities, everything from staff augmentation. I personally was in Florida State EOC for both Hurricane Ian and Idalia, all the way to operational support, migrant sheltering support, COVID vaccine support. So we're kind of a small but mighty firm, jack of all trades.
Good for you, Molly. That's great. Michael?
Yes, my disaster experience began with what I call my third career back in 2004 in Florida, the 4 storms that they had that came through there that year. Spent the next 8 years working as a technical assistance contractor with FEMA, moving through the different stages of their different types of specialists, from project specialist, building inspector, building specialist, building assessment team specialist, CEF specialist, those different types of categories. I found that background has given me a lot of good basis for the work that I do now as a predominantly more with the applicants on the applicant side. So with FEMA, that work lasted for 8 years. And then in 2012, began working with the state of Florida for a year. Then 3 years on Hurricane Sandy up in the state of New Jersey, over to GOSEP in Louisiana for 4 years, working with the folks over there. And then since 2019, working strictly with my company and the different disasters that we work on with the different applicants. So the basis for being the project specialist and learning how to write all those projects and behind what's behind that work gave me insight to the different angles that you can follow in the program to try to find ways to make your documentation work if it's not quite kosher or FEMA doesn't think it's quite kosher. And so solving those type of problems is one of the technical aspects of my position with the company that I'm adept at doing for applicants.
That's great, Michael. Thank you. I'll briefly introduce our two colleagues here, Sam Van Kopp and Logan Kemp. They are colleagues here at Nichols Liu. They're an interesting mix in that we have two former clerks from the Civilian Board of Contract Appeals. Sam was actually at the Civilian Board when drafting the rules for the CBCA arbitrations. Logan left there to join us more recently. There's some of these cases cannot weigh in on because he's conflicted out. But together, Sam and Logan know these cases quite well. And we're going to go through this agenda. You can read it for yourself there, how we've categorized these cases. One thing that I think that is interesting about this is you think about disaster assistance work. Like this is hardcore, on the ground, doing the good work that's necessary for the public good, right? It runs into a brick wall, however, when you have government contracts, regulations that govern the disbursement of funds, but the agency, as much as I love the agency, doesn't necessarily teach the state and local governments and grant recipients all of the strings that are attached with the money. And so instead of everybody being on the same page about exactly how to make the FEMA grants flow readily and easily to those in need, there's this tremendous demand, there's this huge pot of money, and figuring out how they fit together in terms of adequate documentation, proving proximate cause, eligibility rules under the cost principles, et cetera. That's kind of where we come in to help navigate what it takes to actually get paid. So with that, I'd like to turn to Sam to talk about the initial key board decisions regarding the adequacy of documentation. And before Sam jumps in, I'll just tell you, this isn't FEMA specific. When we first went into Iraq 21 years ago, the big issue was adequate documentation. Turns out it's not real easy to keep receipts in a war zone. This is just another iteration of documentation, except there's something a little bit different here. There is a before and after aspect to what was the shape of the asset before the natural disaster, what was the shape afterwards that allows you to actually get ahead of documentation a little bit easier than you can in some contingency type environments. Sam, do you want to start with the Bay County case?
Yes. So this is, we chose this as the first subject because it's the most common issue that's brought up before the board in arbitrations. Bay County is an interesting way. It demonstrates that the board sort of resolves these cases in one of three broad ways. The interesting thing about Bay County is that during the course of performance, the contractor had conferred with FEMA and had given FEMA an overview of how it intended to document its work and its costs. It would create engineering reports. They would identify costs in those reports. They would identify the work that would be submitted to FEMA. After the project's completed, FEMA then decided that the level of documentation was not adequate because it did not adequately identify input costs, specific input costs for specific pieces of work. The board, when they evaluated this, they looked at that communication that occurred during project performance. And the board found that because at the time, FEMA hadn't identified inadequacies in documentation. And because the documentation itself fit, the board believed, the substantive requirements of PAPG's documentation rules, the board found that the work and costs had been adequately documented, and so it awarded the costs to the contractor. It's an interesting case in that it's going a bit beyond the strict requirements of PAPG to look at this sort of course of performance and to have that inform the award decision.
So course of performance, Sam, is a common government contracts technique, right? And just to get into the details, there's the question, what is adequate documentation? And if the parties have essentially agreed throughout, we're doing X for documentation. The government says that is good enough. That is course of performance. But what this is really about is interpreting the PAPG and the grants themselves to determine what is the standard for documentation, right? So it's not exactly an arbitrary line, but there is a lot of context around it. Is that right, Sam?
Absolutely. And I'm sure we'd be interested to know how common this sort of disconnect occurs on the ground in practical life, Molly or Mike. How frequently you have sort of an understanding with FEMA during project performance that might change after the fact.
Mike, do you want me to kind of kick it off from the state side and then I'll throw it to you?
Well, absolutely.
Awesome. I think I mentioned formally I was a state public assistance officer for state of Nebraska, and I can say wholeheartedly that this is something that we struggled with many of our communities. I think timing is everything for a disaster. You don't really know. I know that this case specifically is pertaining to permanent work, but to try to sell any sort of preparedness or organization or even training on documentation before an event is really hard to do, especially in these rural areas with lack of capacity, capabilities, things like that. I will say that, from the consulting side, that we've seen some innovative approaches with different states to address this, because I think I knew it was a problem with my state, and my counterparts in other states knew it was a problem as well. And without that firm consistency coming from FEMA, having different FEMA folks tell you kind of different things, yeah, that will suffice, no, it won't, and that inconsistency and that lack of continuity, as some people on the call probably know, numerous PDMGs, numerous even IBDs. I'm using a lot of acronyms, so I apologize. Program delivery managers, infrastructure branch directors, especially long disasters. There's a lot of movement and changing and staffing, and with that, expectations and experience changes. So I will commend, for example, state of Florida, which a lot of these examples are directly related to, has recognized this problem. And I don't want to speak for the amazing FDEM staff, but they've recognized this issue and they've taken it upon themselves to create a system for Florida that will working directly with FEMA Region 4 and headquarters, having a series of checklists, having some templates, having trainings before the event to ensure something like this doesn't happen again.
Michael?
Another aspect I'd like to raise in this regard is that a lot of applicants nowadays have consultants. I know it's easy for someone like myself to see what needs to be done and the documentation that's necessary, regardless of the category of work, A through Z, A through G. But you have a lot of consultants who have not really ever lived through closeout. They've never stayed with the projects long enough to see their applicants get to closeout, to see what all is required. And so in working with state agencies like FDEM, and especially with NJOAM and also with GOSEP over the years, I've come to the conclusion that a lot of the onus falls back on the consultants. The applicants are oftentimes during a disaster, they're working long hours, they're tired. The last thing that they need is all these other asks that FEMA is putting upon them because their personnel are stretched thin. So from my standpoint, that's when the consultant should come in and be the solver of those issues, come in with a checklist of things that need to be done, the documentation that needs to be provided, And because it differs a little bit by each one. Category A documentation, because the debris is different than the category B, and it's certainly different than category E for buildings and equipment. So from I was happy to see that what GOSEP did for the disaster that they had most recently with Ian, and also that also kind of began with, I guess it began with Hurricane Laura back in 2020, was that they took staff who were there already, who were consultants, who were part of their 3-year technical services group, a group that I was in for 4 years. They took them and they took those companies and hired their additional personnel to go out into the field and teach these applicants, especially the smaller ones, what needed to be done, what documentation was needed, how they needed to document the damages. And that helped an awful lot in regards to the overall recovery aspect from the applicant standpoint, for recovering the dollars that were spent and needed to be recovered, and to capture the damages that were done most effectively.
Yeah. Michael and Molly, you both raise a good point about taking the time to learn about adequate documentation and plan for it up front, which, let's face it, nobody wants to do that, right? But versus seeing how these things play out, whether they get denied, whether you have a meeting of the minds with your grants officers, whether when they do get denied, whether the board will come in and overrule FEMA effectively and say that that was enough. This issue of adequacy of documentation and meeting of the minds, I think is the grease that makes these things flow smoothly, but a lot of them don't flow smoothly, and they have real dollars involved. And we do rely on the board to come in and be a check on FEMA when FEMA is requiring more than what the POPG or the grant requires in terms of documentation. Logan and Sam, could you talk about comparing the Village of Pinecrest case with Miami-Dade, and talk a little bit about the policy and the approach that the board applies in terms of deferring or not deferring to FEMA?
Absolutely. So in the Village of Pinecrest, FEMA had denied $2 million in emergency work to clean up debris after a hurricane. The applicant, when they submitted their documentation, they provided crew logs and daily reports, which included photographs and GPS coordinates of some of the logs that were cut and removed. FEMA said, when they denied the cost, FEMA said that the applicant had to produce photographs and GPS coordinates for every single log that was removed in their debris clearance. The board, when the case got to the board disagreed with FEMA, and the board noted that in the PAPG, the applicant is not required to submit photographs for their documentation. Instead, the PAPG just says an applicant may submit photographs. And so the board did not view this as a requirement. And so the board found that these photographs were sufficient documentation. The board also noted that described the applicant's cut and toss work as debris clearance, which the PAPG does not require quantification for, versus debris removal, which does. And so I think this case is a good example of how, while the board does apply FEMA policy on what needs to be included in documentation, the board doesn't defer to FEMA on the specific what is in the specific documentation. Sam, do you want to talk about the Miami-Dade County case?
Sure. So Miami-Dade is helpful to pair with this because it represents sort of the majority of cases come before the board where the applicant cannot actually demonstrate adequate documentation. Miami-Dade, in a nutshell, the evidence that was supposed to substantiate the eligible work was limited to a series of timesheets. And these timesheets were paired with narratives that described in general terms what work was done during those hours. But that was the limit of the documentation. And the applicant's argument was this special timekeeping system only applies to emergency work, and therefore it should be presumed that this work was performed for eligible emergency tasks. But the board, I think, correctly pointed out that that is not sufficient under the PAPG. You do have to provide details about the work itself. So it's a reminder, these three cases, Pinecrest, Miami-Dade, and school board, sort of give you a general sense of the three of the avenues in which the board resolves these inadequate documentation cases. And Robert, to your question, we do talk about deference in a later section, so perhaps I'll save it for that.
So Michael and Molly, what best practices do you and others in this field follow to avoid documentation issues like these and to memorialize, especially given turnover on the government side, memorialize when we do have direction, instruction, acceptance of a particular types of documentation from the government?
I'll
Sure.
lead off. I'll lead off on this one if you don't mind, Molly.
Yep.
And so at Aptum, we practice what we call proactive engagement. With proactive engagement means that if something comes up down the road with FEMA, you're not surprised because you expected them to raise that issue. So you have the answer already is at hand, or you've incorporated that into your documentation. For example, take an applicant who is a cooperative, electrical cooperative, and they have had to put in a facility, a tent city, so to speak, to hold maybe 1,000 workers. And so as part of that process, they've had to procure that. Okay. So knowing that that would be an issue for FEMA and ultimately for the grantee as well, whether or not it was done competitively, then what we do as a consultant is we advise them on the front end that they need to make sure that they've done it competitively, even if it's done as an emergency procurement. So, and if we think that there's an issue with it potentially being and coming up with FEMA, then we do proactively provide something like a reasonable cost determination that we do with that. So we have the checklist that we follow, and the checklists are good, but then only we as the consultants know from the many disasters that we've been in, the many different types of situations we've been in, only we know what kind of issues FEMA could raise in regards to those, and therefore we're prepared for that as a team when we go in because we know it's going to come up eventually, if not on the front end.
Unmute, Molly. Okay. I would say our approach is similar, but this question always intrigues me in the way I respond. I like to view it with a lens of equity. If you think of our country, right, in the jurisdictions within Village of Pinecrest, Miami-Dade County, Miami-Dade County, if you think of capabilities, if you think of resources, if you think of probably the investment and planning and just the infrastructure and the framework, they should be the best of the best, right? That's, I mean, I just admittedly would think gold star for Miami-Dade County. But when we were thinking about planning for recovery and documentation support, if you contrast that with a small rural beach community who has a city manager and maybe a public works director on full-time staff, maybe a part-time clerk, what does that look like with the lens of equity? But being able to prepare and really be able to have this infrastructure, two, the education and knowledge in place to be able to, one, respond, right? Emergency work, they're responding. Imagine, Andrew, yes, hit Miami-Dade, but a Cat 5 hurricane making landfall with a small jurisdiction. They're responding. They're not thinking about making sure that they're writing on their timesheets that they were, sandbagging and putting up barricades and things like that. So I think we have to take a different approach with each jurisdiction. I know for my firm, we try to meet our clients where they're at. I live in rural Nebraska. I don't know if I mentioned that. So that's kind of where my heart is assisting these rural, smaller communities being prepared and being ready for this. And so any sort of training and kind of front end preparation is important. But of course, in these smaller jurisdictions and these less well-off jurisdictions, finance and funding is always a concern. And I think that is everywhere. There's not really a funding mechanism to prepare for recovery. Everyone wants to use their preparedness grants for response, wants to do it for, that first 36, that first 72 after an event. So I'll say in terms of best practices, I don't think there's a one size fits all approach. I think, as Michael alluded to, the checklist, really ensuring that we can share our message and communicate on the front end. And in terms of consulting, so many consultants, our contracts are on retainer until something happens. And so that's kind of hard when it's it's a little bit too late, right? I always say to my clients, best practice, call me before. For Ian, I was there before landfall, so I could help organize documentation. I could help advise, yes, if you're going to go do that, do it in the vein of life safety and protecting property. You absolutely have to do it. And I never want people to make response decisions based on PA eligibility. That's not okay. And if we're thinking that, then that's not okay. But to be able to advise and coach them on, okay, if you're going to do that, make sure you're tracking this, this, and this. So I would say that's a best practice. Bring your consultants in as early as possible, get things organized, have that documentation unit, that SIT unit, finance and admin organized and ready to go. So then when and if the federal declaration comes, hopefully things are a little more organized.
Yeah, that's helpful, Molly. Thank you. Sam, let's jump to the proof of damage, that the damage was the direct result of a disaster and the City of Panama case. Can you talk about that?
Yes. So Logan actually will walk us through this case. It is, I think, the most important case of last year, and it's one of the more maybe top 10 that the board's ever done. Logan, would you like to take it away?
Absolutely. And it's a very unusual case where the court outlined almost something close to a bright line rule on what you need to prove quantum for damages for road damage that resulted from a disaster. In Panama City, the board denied nearly $9 million in road repairs because they said the city cannot prove that it came from the hurricane rather than from poor maintenance. In a in a lucky stroke of instances for the city had actually done a survey of all their roads a few months before the hurricane had hit. And this survey had produced an index, a pavement index for each road, rated from 0 to 100, with 100 being good. And so after the hurricane, about a year after the original survey, they conducted another survey. And again, they got this index for every single road, and they compared those two results. And so the applicant argued that anything that had been any road whose index number had declined by 7 points or more should have their costs should be granted to repair those. FEMA had again disagreed, saying that the applicant couldn't prove that it was a result of the hurricane. The board agreed with the applicant in part. The board said that they would only fund repairs to the existing pre-disaster level, which is what FEMA's policy says. And so they would disallow any costs that would make the roads go above the pre-existing index number. However, the board also said that they would disallow any index number that was below 55 because they said those roads were already so poor that the maintenance might have actually been what caused it. You can't prove it was because of the hurricane. But roads that had declined by 10 index points, which is what the board used, because they took 7 as a result of the hurricane, and then they took there was testimony that 2 to 3 index points was the typical degradation per year. So the board took those two numbers together and said, hey, if your road was above 55 before the hurricane and there was a decline of 10 points or more, FEMA should fund the repair costs to the pre-existing level. And ultimately, this is a very unique case, but I think it's a good example of how applicants should be thinking about how to prove their costs. Sam, do you want to talk more about this case?
I think that's the most important point. You get almost close to a bright line rule of a certain number of index points lost over the course of a disaster. But to turn it back over to our special guests and Robert, I'm wondering as a practical matter, in the absence of really good data like this, how difficult it is to attribute costs, to attribute damage specifically to a hurricane. And similarly, how realistic it is, or what an applicant could do to do something like, as occurred in the City of Panama, a sort of survey that could last for 10, 15, 20 years and give some sort of benchmark used for all previous disasters, for all subsequent disasters.
May I jump in?
Please.
Okay, so this is a topic that I've run into a lot and had discussions with numerous applicants about, and that is the roads issue. I know that my company is Aptum. We're out of Baton Rouge, Louisiana, billion-dollar company. We're a small practice for the recovery group and resilience group within them. But we've run across this in a couple of different appeals that we've worked with. Didn't get to the arbitration stage, but we advised and made advisement for how they might handle these routines. And so you've got the damage to a road that's caused by all the heavy equipment that's on it, like from a hurricane. Then you've got the other aspect for a flooding, where oftentimes you have roads that are underwater. And when the roads are underwater, then of course the base is wet. And if you bring heavy equipment across that road continuously, then that base, which is wet, is not, it will lose its integrity, and you'll have a failure of the road. Mm-hmm. So the argument that most of the applicants bring to the table on these road issues like this, and all the wear and tear on the roads from the heavy trucks, is where they expect to get reimbursed by FEMA for these damages, and FEMA is saying that it's not disaster related. So there's two ways to go about proving this. In the past, for a flooded road, the technique that was used by my company and successfully turned $0 into $32 million for an applicant in Louisiana was that they did core samples of the flooded areas of the same road. They'd pick a road, do core samples of where it flooded and was underwater, do core samples where it did not flood for a comparison. When they did this for several roads, and when they came up against FEMA's professional expert on the topic, then they didn't have a leg to stand on, because the core samples showed what the differences were. FEMA then turned around and changed their policy. They said, well, we will no longer accept core samples. It has to be visible damage. So then they're thinking, okay, visible damage, you can see the visible ruts in the road that are caused by all the trucks. But then FEMA comes back and says, well, so what kind of condition was the road in? Can you prove that it was the trucks that caused the damage? Well, common sense tells you that it was, but that they can't draw the direct disaster related comparison with it. So two solutions came to mind for me with this. One's going to sound kind of off the, that it doesn't make a whole lot of sense when I say that what I'm advising applicants to do that have sufficient amount of damage where they know they're going to have a lot of vehicles going across their roads is to have the vehicles be downsized from no bigger than 20 cubic yard capacity, because then it brings them down to a size that's within the weight limits of the roads for most typical roads. When you go up to the 40 cubic yards and bigger type capacity vehicles, then you're exceeding the weight capacity of the roads. And so FEMA can say then it was negligence that was involved. So we have to find a way to put it in FEMA's face and rub their noses in it, to let them say, hey, we can extend the debris removal process and save our roads and cost you $30 million more. Which would you rather do? Spend $10 to repair the roads after they've been gone over, or $30 million more because we have to extend it for over such a large period of time for the large disasters? So it's obviously washouts are not an issue because you can show where the washout occurred. But as far as this is concerned, this is the kind of guidance that we're giving our clients, is that they should take another look at their debris contracts that they have preset and make sure that the equipment is smaller, unless we can get FEMA to agree to the fact that if they're going to go with larger vehicles to do it quicker, then we're going to have some recompense for the roads.
Thank you. Sam, let's move on to the next section.
So the next section is an important one. It shows up in every case essentially, and it's something that clients often ask us about: the degree of the board's deference to FEMA policy and procedures. The important thing to note here is that the board views its deference differently under its current authority than it had viewed its role under the Katrina authority, which is how it conducted arbitrations for years before this. Under Katrina, the board had been looking at its role as a court who reviews an agency action in the same way that any court might review a government action. So there's a whole series of procedures of formal deference that applies in that context. Under the new procedure, the board views itself as stepping into the shoes of FEMA to decide and apply FEMA policy in order to make a decision. And under this context, there are no formal rules of deference. It comes down to what the board feels is appropriate to take in terms of its assessment from FEMA's guidance. The most important decision on this subject was the very first decision the board ever issued, and that's Livingston Parish, which I understand, Michael, actually you had been involved with. So I'd love to get the backstory there. But for legal purposes, in terms of its impact on the deference doctrine, the importance of Livingston is that the board will defer to FEMA, but only in, quote, circumstances where FEMA persuades us it's settled the issue. And what that means in practice is there's a whole range of deference that gets applied depending on the type of question that's before the board. So the most deferential cases are those where FEMA has a rule, it's not well articulated how the rule's applied, the applicant can't point to any other evidence or any other FEMA policy that might support its position. So in these circumstances, the board will often defer not only to FEMA's written policy, but to FEMA's interpretation of that written policy. Best example of this case in the last year is the town of Topsail Beach in the bottom left-hand corner. The issue there was essentially how far you consider the beach to extend when assessing how much sand is necessary to replace it because of the direct result of hurricane damage. So how far that beach extends, the applicant's whole entire position was that it wasn't rational for FEMA to make the call it did in terms of how far it extended. But the applicant couldn't point to an alternative piece of policy. So it was stuck having to simply argue that it wasn't rational. And that's not sufficient. The board will defer to FEMA in those cases. On the opposite side of the spectrum, you have those instances where the board applies the least amount of deference. And that has to do with questions of timeliness or jurisdiction. So Larimer County is the best example of this in the last year. These are the most spicy decisions the board issues. The language in these cases gets very close to being angry at FEMA policy. So in Laramie County, FEMA's position was that an applicant was late because it had submitted its appeal within FEMA 60 days, so on time, but the recipient hadn't forwarded it with their decision within 120 days. So no fault of the applicant, but FEMA's position was that is untimely under the straight rules of the PAPG and Stafford Act regulations. The board's response was FEMA does not get to decide what is timely for the purposes of the board's review. So even though the rule itself had to do with an internal FEMA question, the board cited to Supreme Court precedent, of which there's quite a bit recently, discussing whether issues are jurisdictionally barred from being brought in courts. And based on that Supreme Court precedent, so way outside of FEMA policy, the board decided that the case wasn't late and it could be considered and heard in arbitration. So that's, I think, as far as you can go for not following deference. And a good example of a case in the middle where the board is not sure whether or not to apply to FEMA policy is Nashville-Davidson. I think Logan will speak about very quickly.
Yeah, and just to do it very quickly, it's a case where the applicant was trying to get police costs that were used to protect against potential looting and vandalism that they predicted was gonna happen after a disaster. The whole question was whether this is a direct result of the disaster. The board kind of sidestepped that question, but the question that they did resolve was that the FEMA had said not only is this not a result of the disaster, but there wasn't sufficient documentation, and the board agreed with FEMA on that point in that they said these are just short-term costs that were operating costs. These weren't longer-term costs, and they pointed to the lack of time entries after a month that showed that the police were just doing their normal operating business. They weren't no longer doing search and rescue. And so I think it's a good example of what Sam talked about.
So the scope of permanent work and emergency work obviously is vast and varied. It would seem impossible to task FEMA or any agency with designing standards to fit any situation. Molly and Michael, in your experience, how often do you have to rely on FEMA's word on the ground that such and such actions constitute eligible work?
You want me? I can start with this one, Michael. I think in 2017, when the FEMA Public Assistance process changed, I think that changed a lot of the communication, a lot of the understanding of the process across the spectrum from federal down to state and local consulting. I think it was a major shift. Regarding boots on the ground, with that change in the FEMA PA process came a lot of new to the program, new to FEMA staff. And, you know, a lot of tech contractors. I think that experience level, you know, just pivoted and changed. And so in a space where prior, maybe we had that really good communication conversation, boots on the ground in the joint field office from the state side, we started to see a shift, I would say, in that collaboration and that communication a bit. I'll say PDMGs, program delivery managers, are, I would hope, told not to make eligibility determinations or even advisement in the field. That is not their job. But because it was determined that that's not their job, that has caused the process itself to have some inadvertent consequences. It takes longer. Eligibility determinations take longer. It has to go up the chain. It has to go to the CRC, you know, all of these things. So I will say in the field, we just don't have the flexibility that we used to have, being able to kind of collaborate and work through problems before they become problems.
From my standpoint, the FEMA's change to the virtual desktop reviews puts everything in a two-dimensional type of a presentation. There's just no substitute for being in the field and seeing the three-dimensional damages. No substitute for us. From my standpoint, for the applicants that I represent, I've been in and taken a look at the damages that occurred on their facilities. I have a chance to look at them from the same viewpoint that I looked at disasters when I was a project specialist with FEMA. So bringing that skill set into I think is important, to have people that evaluate the damages, who are familiar with what FEMA does consider to be eligible over a period of years, so that when you see it again in the current disasters, you go, that's eligible work. And if FEMA argues with you, you say, so how many disasters have you been on? Is my typical comeback. Oh, this is my second one. I worked at so-and-so and did this. So that's not the answer that I'm looking for from FEMA. So I tend to see that because the experienced people with FEMA are clustered back in the CRC, the resource center, central resource centers, they have 3 of them now, that they would understand if they were in the field, because a lot of them were still doing the in-field type evaluations back prior to the beginning of the grants portal era, and now what I call this particular tabletop evaluation issue, tabletop review, they call it. So the important thing is to get people in the field early who understand the actual damages, who can differentiate between what was already there and what was caused by the disaster, so that you can document it, photograph it, GPS it, and then present it in that format. If it's presented that way with enough documentation and enough backup from forces and people who are familiar with the actual roads or familiar with roads in general, then that solves the issue, like for Livingston Parish and other areas. But that's the way I would look at it, is from our standpoint.
And I still can't help but view these examples through the equity lens. You know, the example of we needed them to help with security, with looting. That's what that community needed at that time. Maybe they didn't have mutually, they didn't have the capacity. And so I think, to your point, you know, it's FEMA can't really create a policy that's one size fits all. But if it falls, you know, if it's in the gray and that's what that community needed, and oftentimes those are the communities that need the federal support right after an event. They don't have this robust mutual aid or resource network. I find that they are the ones that are suffering when it comes to documentation and being able to demonstrate that they did the work. Maybe they have this maintenance policy, but they, you know, they didn't take pictures every single time they cleaned out a culvert or things like this. It's, you know, and so then they think that this is insane. They think the policy is insane. They don't have the capacity or capabilities to do all of this. And then they're the ones inadvertently, you know, most impacted by not being able to be reimbursed for all their expenses.
Just one other thing I'd like to add in regards to this, and that is that oftentimes the applicant has documentation that they don't realize they have that could be useful. And I've always considered myself to be an angles person, from working from the angles to try to find the documentation that is useful. In other words, and so, for example, I took a cooperative, electrical cooperative, who had failed to take photographs of damages to over 4,000 poles, thousands of linear feet of wire, 2,800 transformers. But what we were able to broker with FEMA was the fact that they did have GPS locations because they had pole numbers on every one of their poles. They could identify the poles they had recently purchased by their pole numbers, and some that didn't have pole numbers because they hadn't had chances to be processed at the factory. So we found a way to get around the fact that we couldn't do the typical tabletop review that FEMA wanted to do with all the photographs, because we found an alternative that the applicant could support and could provide. And we ended up getting no dings whatsoever on that $64 million project.
Yeah, that's good, Michael. I think our teams, that's what we do. My team does well. I'm sure Michael's, your team and other consultants do very well, is we have to think outside the box. We have to think creatively to kind of back into those policy requirements. So I would say that's an advantage of partnering with a consulting firm as well.
Yeah, and it begs the question, what happens if after all of that, there's still not an acceptable pre-disaster condition report? One of the attendees asked a good question. Okay, but what if we don't have one? And the answer there actually goes to CBCA case law. In the context of Iraq and Afghanistan, the CBCA issued a number of decisions over the years that said, if you just simply don't have contemporaneous adequate documentation, come in after the fact and do declarations and sworn affidavits from people. And we will, if we find them credible, we will rely on that. So it really is a matter of, if FEMA says we don't have enough, what does the board say in terms of what is adequate documentation on the facts on the ground? Let's turn to COVID costs, Sam. You and I are very conscious that during COVID, the government was, rightfully pushing for a lot of mitigation efforts from everybody, contractors, grantees, etc., with a suggestion, at least, we will cover costs. Reality's been a little bit tougher. Can you talk about how these cases have played out?
Absolutely. This is an issue near and dear to my heart. I was at the board actually when COVID struck, and we were there the day that the chief judge called us into a room and said, go home, don't come back. And so a lot of the policies in those first few months gave agencies, not just FEMA, but many other agencies, discretion to afford costs. And what we found, both in the FEMA arbitration context and in our other government contracts work, is that the agencies have exercised that discretion to deny the very costs that they have been pushing so hard for folks to incur. So it is a sad story. It is played out a little bit differently in the board, though, which is quite interesting. And this also, so the next case, joint meeting of Essex Union Counties, it's the high watermark, I think, of the board using its own interpretation and not deferring to FEMA policy on something of an equitable level. So spoiler alert, this is a case where the contractor recovers, or the applicant recovers, rather, its costs. And the most important thing to know about this case is, and this touches to something that Robert said a moment ago, the board are primarily Contract Disputes Act judges. They primarily do normal government contracts work. FEMA arbitrations is a new field for them. So every time they look at these cases, they're really looking at it from a lawyer's perspective, and specifically a government contracts lawyer's perspective. And you see some of those interpretive moves in this case. So long story short, we have a wastewater treatment plant. It has to keep its employees on site. They can't go home because otherwise they might get infected. And if they are infected, they can't go home or come back to work. FEMA denies overtime costs for these individuals because the facility itself wasn't needed. Let me back up. FEMA denies these costs because it's seen as simply a normal operating cost. And under the PAPG, in order for a normal operating cost or increased operating costs to be eligible, you have to demonstrate that there was an increased need or demand for that service. And since these individuals were stuck on the facility itself, wastewater treatment service was always available. It didn't fall out of need. And so there wasn't an increased need for these costs. And therefore FEMA denies it. Before the board examines the PAPG policy. The board explicitly acknowledges that this increased demand exists as a requirement, and it acknowledges that the wastewater plant can't meet it. But despite that fact, through its assessment of the totality of FEMA's regulations and the totality of the PAPG's requirements, the board finds that this could be considered overtime costs. And it pins that rationale to the fact that the wastewater treatment plant did have an overtime policy before the disaster. It was nothing like the overtime policy that actually occurred during the disaster, but it did exist. And because the PAPG allows overtime costs to be paid if there's a pre-existing policy, the board fudged the rules to find eligibility in this case. So I think this ties together a lot of the strings that we've been talking about, Robert, thus far today.
Okay, thank you. Let's move on to FEMA or the board's interpretation of the 50% rule, Sam.
So this is a very complex issue, of course. Michael, I believe actually you testified before the board on this issue. Is that right? What case was that?
The issue was before the board was the Archdiocese of New Orleans. It was
that under the Katrina
it was actually
Authority?
a follow-up. It was actually a follow-up to an original arbitration. The original arbitration was to show that we had damages that would qualify as more than 50% of the replacement value. But then when FEMA messed up their ruling and we had to come back again, then we brought our own replacement model and won on those, won in that case.
And that's the circumstance that's happening here in Hadesburg. And so this is very much a dueling battle of the experts field.
And down south, Sam, we call that Hattiesburg.
Hattiesburg. Thank you very much. Thank you.
Okay.
Local, yeah. And so this is a situation where, again, FEMA is trying to read its policies very narrowly. So the issue was whether replacement was adequate. It came down to a question about whether or not the building had suffered, quotes, substantial damage. And the policy documents that had provided for the code upgrade that would be necessary for replacement. So basically that was the precise issue in this 50% formula question. That policy document only talked about this substantial damage in the context of a flood hazard zone. And this particular facility had been destroyed during a hurricane. So hurricane weather event, and without flooding. And so the board looked to the policy as a whole. They looked past what they considered to be an unimportant distinction, a distinction without difference. And they found that the applicant was entitled to replacement of the facility rather than repair. But in my experience, these are far and away the most complex factual cases that I've seen before the board. I wonder, Molly, if this is something that you've run into too, and how you address or try to walk a applicant through this.
Yeah, I would say in my entire career, nearly 15 years, even back, when I represented my state and I was very much boots on the ground, I've never seen this policy applied correctly the first time. I think it is a messy policy the way it reads, especially as you start to incorporate codes and standards, and even as FEMA continues to change codes and standards requirements, it's just very, very messy. And then when you throw in, especially our friends on the coast, any sort of floodplain requirements and any sort of, or here in Nebraska, when we flood, elevation, or does it need to even be another bridge? Does a box culvert make sense? And just having that discussion, I'll say, the applicants I've worked through this process with aren't hesitant to seek replacement. I think they know what they know. And when bridges, here in Nebraska, we have state codes and standards that we can't rebuild wood bridges. You just can't. And so just even being able to justify, personally, I had to go through a 3.5-year appeal process to second appeals just to get that covered historically. But I would say, speaking just anecdotally, that applicants are just hesitant to make progress on any work just because they don't know what's going to happen with the funding. And I hate to say this, because what I usually tell my clients in my communities, is, you know, would you do this if FEMA wasn't here? What would you do if FEMA wasn't here? If you were paying for it out of pocket, what would you do? That's usually a pretty good heart check, right? Of like what people are willing to incur on their own, and if they're trying to take advantage of the federal government. But they're just unsure of the outcome, given the application of the rule. It seems to be applied a little bit differently, and the calculation is complex. So I think best practice more recently when I went through this was to find one vendor that can do in-kind repair and estimate together, and really navigate that very, very closely with the CRC and the PDMG. I just think the way that we're moving, you know, this put back to pre-disaster condition. I know we had a couple slides. That's hard to navigate as well, especially for some of these bridges that, yes, they're not substandard, right? They've been inspected, they were approved there, but the justification for then needing a replacement, or what do we put back, what was not substandard but adequate at the time, and then mitigation comes into play, right? And so I think just a side-by-side comparison allows reviewers to identify same components, hopefully, you know, line by line, but really active engagement with engineering at the CRC is best practice.
I'd like to do a follow-up to what Molly just said, and to continue what I was saying about the actual process for going through the 50% rule analysis. So what I run into oftentimes in the field is this. After a tornado hits, or a significant hurricane hits, or after flooding, you find lots of applicants who are trying to replace older buildings. Okay, so the issue then is that you have to go into it looking at it from the viewpoint of what damages to the building or the structure were caused by the disaster, and we're not already there pre-existing. That's one issue. The other issue is that oftentimes I see that people are rushing to try to get replacements, and they're being kind of biased in their estimates. For example, and this is not to disparage engineers or architects, but if a building is damaged, they're going to want to put it back in pristine condition. Well, not all of that pristine condition involves components that were damaged by the storm. So there's that give and take there as well that you have. So when it comes to the actual figuring of the 50% rule, you have to go back then also to your damages. In the case of the Archdiocese, the damages were such that FEMA was making their damages less because they were replacing certain components with inferior components. They called this cost effective, and they stated that it restored it to its form and its function. But wait a minute, there's a third factor that has to be considered, and that is the design. So if you have a hollow core door, you're replacing, if you have a solid core door and you're replacing with a hollow core door, it's not the same design. If you have walls that are plaster over metal lathe or over wooden lathe, you don't recreate that same what's the word I'm looking for, integrity and usefulness. And also, if it's going to be used in a situation where it's like separate offices or rooms where you have that same type of security, you don't replace that by coming back with sheetrock. So, and I know what we went into the arbitration with for the Archdiocese is that I was the estimator who was the expert, presenting my estimate versus FEMA's. I made sure I knew my estimate better than FEMA's estimate. Okay. Very important. I made sure I knew my replacement value better than FEMA's replacement value, better than they knew it. So as a result, when we came before the jurist and we presented the fact that it was not repair in kind, and they said, why not? And Judge Lester, who was on last month's webinar, was the lead jurist for that. He said, so what is repair in kind? I said, repair in kind is what I was taught as the project specialist, where you put it back like it was. If it had wooden floors, they get wooden floors. If it had solid core doors, you get solid core doors. It puts it back like it was. If you had metal windows, you don't come back with wooden windows, you come back with metal windows. So we took that concept through that first process, which was to build up the value of our claim for what was damaged. Yeah. And the board agreed with us in all the aspects of that. So then it came to the actual 50% rule, and we won on like 53%. We went in with 53.5, which was very tight. and it was very rewarding, because it, just like Judge Chadwick said in the first seminar from a month ago, how was it he put it? He said that when you're presenting your case, what's right about your position? And what was right about our position was that we knew the structure, we knew the estimates better than FEMA, and came prepared to debate them on those points. And the jurists listened and made their ruling based upon that. So anybody expecting to go to arbitration, the first thing is to get somebody to evaluate your claim to make sure it's not biased, and to make sure that you actually do have a claim, both for your replacement model and for your damages. I've seen a lot of money wasted on people trying to do something that didn't fit, trying to fit that square peg into the round hole.
Michael, speaking of square pegs and round holes, we're out of time, but the materials talk about the Sony electric case and some others. Cost allowability is a really big issue here. And this is where the cost allowability rules for 2 CFR, while those are not particularly well litigated, since 2 CFR isn't really litigated, the cost allowability rules that come in, then they're almost identical from the contract side, can be very informative to meeting the cost allowability standards under 2 CFR. Sam, I don't think we have time to hit on those cases, but do you have any final comments to wrap up?
Yeah, just that point that, so there's a huge body of case precedent about 2 CFR outside of the FEMA context. And that is the context the board knows. It's another reason why it's helpful to have lawyers who do government contract law be part of the arbitration process, because we are speaking the same language in that. And the language is not going to be the same that FEMA is talking about. We have this whole back history that just FEMA isn't aware of. So it's good to do your homework there and have a representative who's well-rounded.
Great. Michael, Molly, thank you so much. Logan, Sam, thank you. Appreciate all of the input on this today. And if you have any follow-up questions, feel free to reach out to any of us. Anything else, Sam?
No, sir, that's it.
Okay. Everybody, thank you for your time today. We hope this has been helpful, and look forward to this next webinar that we'll be doing on another of these topics in the coming months.
Thank you, everyone.
Been a pleasure.
Thank you.
Bye.